Good morning. Today we're going to hear from four very well-qualified judicial nominees. One to the District Court in the state of Vermont, without being overly parochial, and three to the U.S. Court of Federal Claims. And I'm happy to welcome Vermont Supreme Court Justice Geoffrey Crawford. Justice Crawford has a significant criminal and civil experience. He's a Vermont trial court judge for 11 years. He recently became an associate justice of the Vermont Supreme Court. In fact, the governor's comment to me when I recommended Justice Crawford to the president was, "Hey, you're taking one of our best Supreme Court justices." He formerly was a partner in a Burlington law firm, and I'm glad to see Jerry O'Neill here in the audience. Justice Crawford earned his BA cum laude from Yale, his JD cum laude from Harvard Law School. I recommended Justice Crawford to President Obama after he was vetted and recommended to me by Vermont's nonpartisan Judicial Nominating Commission. I didn't know him before this process. I read the report of those who did the work of the nominating commission, and then I met for extended time Christine Lucius, the chief counsel, and myself, and John Tracy, the head of our Vermont office with Justice Crawford, and I was struck by his brilliance, his compassion, his humility, and his devotion to his family. He's earned a stellar reputation in Vermont's legal community from those who appeared before him as a careful jurist who understands the effects that legal rulings have on people's life. I have no doubt that once confirmed, he'll bring the same understanding and impartiality to the federal judiciary in Vermont. We're just one district, but he'll be sitting in Rutland, Vermont. And then we have three nominees to serve in the Court of Federal Claims. Judge Nancy Firestone, who's well known to the most important member of this committee, Christine Lucius, Thomas Halkowski, and Lydia Grigsby, who served on my Judiciary Committee staff since 2006, currently serves as my Chief Counsel for Privacy and Information Policy. I recommended Lydia to the President for the position because I know her intellect and good judgment will make her a fine judge, and that's what I told the President. Before Lydia came to work with me on the committee, she served in the Justice Department. She tried several matters before the Court of Federal Claims. I did tell her father that this morning that the one reason I might vote against her is to keep her here on the committee, but no, I'll proudly vote for her. Judge Nancy Firestone has served with distinction on the U.S. Court of Federal Claims since 1998. And I'm sure she'll continue that with another 15-year term. And Mr. Halkowski is a principal at Fish & Richardson. That's a law firm specialized in intellectual property law in Wilmington, Delaware. He started off clerk in the court to which he's nominated for Judge Roger Andewelt. He also clerked for then Chief Judge Helen Nyes on the Federal Circuit. So once he's confirmed, his career will have gone full circle. Justice Crawford, I had occasion to talk with the President shortly after I'd met with you, and I told him of your appreciation for his nominee, and nomination. I told him that this is one nomination he won't have to worry about. You served Vermont State Court trial judge for 11 years, and you've been on the Supreme Court now since last year. What lessons do you take from a state court as you transfer over to the federal court?
I think the principal lesson is the twofold. One is the real need to stay close to the facts in every case, to really try and understand what's going on. but even more important, in dealing with the litigants, to try and keep it fresh, to try and bring something new to each case, not to become routine or jaded, to try and really engage with each case anew. And the state trial court judges do a fine job, I think, in both those regards.
I enjoyed my years as a trial lawyer and as a prosecutor, but I left that time with an abiding feeling. The court's judges should think not just of the people who are in there all the time. The prosecutors are well-known litigant like Mr. O'Neill is, others, but the people who are there, this is their one and only time they may be before the court. Can you give us assurance that everybody who comes in your court, no matter what their political party or their economic status or whether they're plaintiff or defendant or government or defendant, that they'll be treated the same?
Senator, I could make that commitment. That has been my effort over the course of the last 12 years, and I intend to continue as I started out. For many people, we are in the courts the face of government that they deal with very directly, and it's crucial that they feel that they've been heard and that they've been treated fairly and listened to with care.
Justice Crawford, and go across the table. I'm going to ask you about some issues dealing with sentencing because you've spoken on that, and at this point don't find any fault, but I want to give you an opportunity to expand. In 2013, you spoke to the press about sentencing practices in your state. At that time, you expressed the opinion that judges have been, as you put it, over-sentencing criminal defendants. You also mentioned that many of those defendants should be placed into drug or mental health courts, and that judges and prosecutors should focus on treatment and reconciliation instead of incarceration. So these would be expand on those statements by saying by my asking, what do you mean when you stated that Vermont's criminal defendants had been over-sentenced? And I have one more question.
Of course, sir. Thank you. It's an important issue. Within the state court system, we see two kinds of criminal defendants, particularly in the area of drug addiction, drug abuse, and drug trafficking. We see the people that make it their living to harm our communities by selling drugs. And for those people, I don't see an important change. I think the sentencing practices have been correct. For people who are addicted and are more customers than traffickers, we've had success in Vermont. I've worked for several years in the drug court, and we've seen real change in people's behaviors, in their ability to support their families, in their ability to return to the rest of us as honest citizens. And it is that group that I think can be directed towards treatment, directed towards drug court type programs, which are no walk in the park. They're strict, and if you fail in your treatment, you spend the weekend in jail. It's almost a sterner model than simply putting people on probation or jailing them for short periods of time. So what has interested me is a commitment from the courts for people who are addicted to redirecting them so that we can get them back in our midst as productive people.
Yeah. What are your thoughts on mandatory minimums, and can you tell us a little bit about your experiences with limitations on sentencing discretion within the Vermont judicial system?
Within the state system, we have only a handful of mandatory minimums. They represent the decision, the serious decision of the legislature to treat certain offenses with particular seriousness and care. and I've always respected that decision and imposed the mandatory minimum because the legislature is in charge of that decision, and I would expect to continue to do so if in the event that I'm confirmed here.
Then that would bring me to the Supreme Court's Booker decision on federal sentencing guidelines. Of course, they're no longer mandatory. So let me ask you a couple questions and then a third one, but two at first. What is your view on the guidelines, and do you believe that the guidelines have resulted in over-sentencing of criminal defendants?
I can't tell you in a numbers kind of a way what the result of the guidelines has been within the federal system. What I can tell you is that what I like about them is it brings out into the open the concerns about sentencing, about deterrence, about rehabilitation, about punishment, which are involved in every sentencing decision. On the state court side, those things are not always discussed in an open way in court. Sentencing guidelines compel the judge and the defendant, his attorney, and the government to talk about them in an open way and to apply them in a way which is more uniform from case to case. So I think those are important positive aspects of the sentencing guidelines.
In the cases of nonviolent drug offenders or drug offenders with little or no criminal history, do you believe that downward departures would be warranted under the guidelines, or do you think that such individuals would be better off in drug court sentencing or setting?
What I can tell you, Senator, is that I have seen success for people that meet in the state system, that people that meet those criteria in a drug court setting where they're involved for 6 or 12 months, meeting weekly, speaking as you and I are with the judge, reporting on their progress. Whether that translates easily into the federal system, it would be difficult for me to say. I've seen it work person to person in the state court system.
Okay. And my last series of questions for you. You mentioned the importance of treatment and reconciliation during your comments to the press 2013. Could you tell us what you meant by that statement? And then let me quickly add to that. If confirmed, would you focus on treatment and reconciliation when sentencing criminal defendants in the federal system? And if so, how would that focus affect sentencing in your courtroom?
What I have tried to do, Senator, in my sentencing practices is to look at each person as best I can as an individual and to make an individual judgment about whether incarceration is required, whether a mandated treatment program is going to be sufficient, whether a mixture of those two is appropriate. And it would be my intention to continue to, within the framework of the sentencing guidelines, to continue to try and make that judgment, separate out the business people who are harming our communities from the people who have fallen into drug addiction, and treat those two as different types of problems.